Hi, I'm Henry Quillian. I'm here at Taylor English, DUMA, with my colleagues. Today we're going to be talking about not the liability for attorney's fees so much, but rather the issues of how do you prove the attorney's fees in a case of various types, and also how do you prove the reasonableness and necessity of those attorney's fees. It's one thing to have the right to recover attorney's fees or a finding by a jury or a judge that you're entitled to an award. It's an altogether different thing to be adequately able to prove your damages such that your award is sustainable on appeal and that you can ultimately get a judgment that's final and you can recover against whoever it is you're seeking to recover attorney's fees from. And there have been a slew of cases over the last 20 years, but a lot of them in the last 5 years, which impact this issue. And so I figured, what good is it to know theoretically what you might be able to do with an attorney's fees claim if you can't ultimately prove it to the end of the day, get an enforceable judgment, and collect the money from the other side. What we're not going to be talking about today, except for as it relates to what's provable generally and what's not, is the bases for recovery of attorney's fees. We've talked about that in other sessions, and we're going to have yet another session relating to federal law coming up. I will sort of review briefly. We're talking about Georgia law here. Please do remember we are not providing legal advice. This is just general instructions and thoughts that you can consider in the course of your activities in litigation. If you're a lawyer, you need to do your own research. If you're a layperson, don't rely on us. Get a lawyer or do your own research, but we are not providing legal advice. However, over the series of Quillian's kernels, we've talked about a whole lot of Georgia statutes and the official code of Georgia, which relate to the ability to recover attorney's fees. One reason why you have to do that is because generally at what's called common law, attorney's fees are not recoverable. It's only if there's a statute that allows for the recovery of attorney's fees or a contract that provides for the recovery of attorney's fees that you can get them in the first place. The statutes, well, the bases for liability that we will generally go through are contractual liability, where one side agrees to pay another party's attorney's fees. OCJ 13611, which is generally known as bad faith, stubbornly litigious, and unnecessary trouble and expense. 91514, which we talked about last time, which is a genre of frivolous litigation. 91168, which is a tort reform law relating to transfer of attorneys' fees and attempt to get people to settle. 51780, which is another genre of frivolous litigation, especially where there's also extraneous damages that could be caused to a party as a result of frivolous litigation. 13111, which relates to recovering of attorney's fees associated with a note or an instrument of indebtedness. And then 3346, with respect to recovering attorney's fees against an insurance company for bad faith. I'll knock this one out easily, 3346, and basically say we're not going to talk about it more except for that if you're suing an insurance company directly, 3346 preempts at least the basic recovery mechanisms such as 13611 for recovery of attorney's fees as a matter of Georgia law. There's an exclusive remedy against insurance companies for bad faith if you're the insured suing the insurance company under 3346. Now, what I thought we would quickly do is talk about the elements that I want to think about with respect to how do we go about proving attorney's fees in a way that you ultimately can get a judgment. And the things that I thought of generally is, do you have to prevail? Do you have to allocate the fees you spend or incur to particular issues on which you prevail? Do you have to do more than just prevail? In other words, prove something a little extra. Do you have to prove a whole bunch extra to prevailing? And then we'll concentrate a lot on how do you prove reasonableness, and how do you prove the necessity of the attorney's fee? Several of these items have been discussed in previous sessions, particularly prevail, prevail plus, and prevail plus plus. But I figured as long as I was making a chart, I would go ahead and put those in there to sort of remind people that certain statutes that basically don't do you much good unless you can really, knock it out of the park, so to speak, and prove your case on a very solid basis. So, one of the most interesting ones that I've studied recently relates to this issue of recovery of attorney's fees where there is a contract that provides for recovery of attorney's fees. And this is an instance where one party agrees to pay somebody else's attorney's fees. We're not talking about the situation where a client agrees to pay the fees charged by a lawyer, but rather where somebody else agrees to pay a lawyer's clients their attorney's fees, whatever they incur. And who would guess whether or not a contract can be entered in Georgia where one party agrees to pay the attorney's fees incurred by another person in a particular situation? Show of hands. All right, well, I see a lot of nods.
Why not?
Yes, so we have, the thing that we see most often is indemnity agreements where, we'll say it's a subcontractor agrees that if personal injury occurs on a project and the general contractor gets sued because of personal injury occurring within the scope of that subcontractor's work, the subcontractor will not only pay the ultimate judgment if a judgment is entered against the general contractor, but also will pay the attorney's fees incurred by the general contractor. What do we think about whether if the contract just says, I will pay your attorney's fees if you have to defend an action for a particular subject matter, does that give an unlimited right to the party who is seeking to get to sue the person on the contract where that person has agreed to pay the attorney's fees to recover whatever attorney's fees might be incurred, no matter how much they are?
Probably not.
Probably not. Why not?
Generally there's a reasonableness requirement.
Oh, why would there be a reasonableness requirement?
Because you got King and Spalding attorneys and things like that that charge $1,000 an hour, which wouldn't be appropriate.
Okay, well, in fact, there are some cases that have come out which address this subject matter. There's one that covers a circumstance where a party did not ultimately recover attorney's fees because of the failure of the attorneys to adequately segregate the attorney's fees associated with the particular work where they had coverage, i.e. defending a claim based on a certain product that they purchased. The Citadel Court versus All South Subcontractors, 217 Georgia Appeal 736, 1995. And it discusses the general principle that in order for Citadel to recover under the indemnity agreement, it must show the fees it claims are reasonable and prove them with, quote, sufficient particularity to permit the jury to distinguish between the time and expenses attributable to the recoverable fees for the XLR plate counterclaim and the time and expenses attributable to the non-recoverable fees incurred in enforcing the indemnity agreement. So here, the attorney's fees for actually enforcing the indemnity agreement itself were not recoverable, but the indemnity agreement provided for the defense in the event the company got sued for a product provided by the indemnitor, and those would have been recoverable fees. But as it turns out, the attorney just got up and he presented testimony about all the fees they recovered on everything, and there was no ability of the plaintiff or the jury to figure out which ones are associated with the defense of the claims. So, but what the court did do is it inserted this word reasonable into the calculation, which if you go back and read the indemnity clause, there's no mention of reasonableness. It just says including attorney's fees. So where in the world did the word reasonable come from when the contract didn't have such a constraint? Anybody got a suggestion on that? Think about your contract law, your basic contract law.
Yeah, but the duty to act reasonably under a contract is a duty between the parties to the contract, not a duty of the lawyers to bill reasonable fees. They're not party to the contract. So is the court applying that duty to the lawyer's fees?
So, Mr. Hill has asked two distinct questions. As between a lawyer and a client, there are duties for the lawyer basically not to ream the client by charging outrageous fees. I think Mr. Fortuna has some comments on that. Where would you find that sort of restriction?
Well, in the ethics rules, there are a number of factors that attorneys should take into account in determining whether they have a reasonable fee. And the ethics rules require fees to be reasonable.
Okay, and so they give you various factors such as your brilliance in the area of law, the location where you practice, what other attorneys in the competing markets are charging, the urgency of the matter, and things like that.
Complexity of the matter.
And so there is a duty between the lawyer and the client to charge what the lawyer and the client agree are reasonable. But there's probably more latitude for a lawyer if they're really, really good or really persuasive, or their client's really, really doesn't care, for the lawyer to negotiate a better fee with the client than the client might be able to recover from somebody else once they incur those fees.
Is the standard for reasonableness somehow related to the law that applies to liquidated damage provisions?
That I don't know.
Well, they have to be reasonable too, don't they?
Well, that has to be a reasonable pre-estimate of the anticipated loss associated with the breach of contract. Whereas this would not be liquidated damages because you would never know in advance
I know it's not.
how much the attorney's fees are going to be for a situation. However, there is generally an implied term of duty of good faith and fair dealing in any contracts that are entered in Georgia. And so that would suggest that if I, Henry Quillian, agreed upon pay Hal Meeks as attorney's fees if he gets run into by one of my associates or whatever, and I agree to cover that for him, that he has a duty not to just spend lavishly on anything he wants in connection with defending the lawsuit, because that would not comport with the implied term of duty of good faith and fair dealing. And I think that's probably the genesis of this Citadel Court insertion of the word reasonable. Now, how is reasonableness generally determined in litigation in the United States?
By the jury.
By a jury. And in what other circumstances does reasonableness determine? In a negligence case. So juries in the United States have lots of experience in figuring out what is reasonable under the circumstances, like similar to the duty of ordinary care, etc. That people can figure out whether something is an outrageous amount or whether, given all these factors, it's reasonable under the circumstances. Judges also, if they were given the opportunity to make the determination as to the reasonableness of the attorney's fees, could figure that out. Now,
So it seems, Henry, maybe it's not that the fees have to be reasonable, but the indemnity only applies to the fees you reasonably should have paid.
that's the way I would lay it out, yes. The indemnity should be constrained by the an implied duty of good faith and fair dealing. And if you're the indemnity, the one that's gonna get reimbursement, and you go out and hire the most expensive lawyers from New York to handle a car wreck case in Georgia, that's not gonna fly. And there's a lot of commercial evidence to back that up. You know, you've got thousands of other cases where people are defended successfully for a lot less money. So the mere fact that you agree to what you subjectively might think is a reasonable fee, because maybe you have other reasons why you're hiring this lawyer, like you want to scratch their back or get some corporate deal that they're working on or something like that. It might be reasonable for you, but that doesn't make it a reasonable fee for the other person who's reimbursing you. So, with respect to contract claims, do you think there's a necessity that you prevail in whatever the litigation is if somebody else has agreed to cover your fees?
Yeah, depends on the term of the contract.
Okay, so the answer there would be only, at best, maybe, because see, I've got a little code up here. M equals maybe, X equals no, check equals yes. So the answer is maybe, depends on the terms of the contract. If it's a pure defense contract, you can still lose, but you can still get your fees covered. All right, but we've already talked about the Citadel case, where the people had a contractual right to recover, but they did not allocate the fees associated with the particular covered aspect of their claim. So the question is, under some circumstances, would you have to allocate your fees among successful ones? And the answer again is maybe, because theoretically you could have a contract that covers everything under the sun. And then I would say there's no requirement of a prevail plus, and there's no requirement of a prevail plus, but do the fees have to be reasonable if you're seeking recovery under a contractual clause? So we generally think yes, they do. Otherwise the case law at least indicates it does. All right, and then how about necessary? Reasonableness and necessity correlate with each other a good bit, but I would contend that necessity is a little bit of an extra constraint on reasonableness. For instance, it might be reasonable to incur fees to look up every case ever decided on an issue, but it may not be necessary at all if you have a Supreme Court case that came out recently that answers the question for you. That might not even be, I see somebody who's not even thinking that's reasonable. But, or it might be, the other thing goes to expenses, such as, do you need the highest tech courtroom presentation equipment if you've got a one clause contract and 3 exhibits that you are presenting at trial? So,
Henry, oftentimes, at least in federal cases, reasonableness goes to the rate, necessary goes to the work.
okay.
So it's $400, is that a reasonable rate? And doing all that research, is that a necessary task that has to be performed?
Okay. I'm going to say that because these are so intertwined that there is going to be a necessity requirement, absent some unbelievably clear clause that says everything, no matter what, whenever incurred and however encountered or something like that, will pay for it. All right. So then we were talking about, so generally speaking, if you write a broad contractual term, that might be the best opportunity and the most straightforward one to recover attorney's fees. And it might allow you to expand what you would be able to recover relative to some of these statutes. Now, does anybody know generally what OCGS 13611 is?
Attorney's fees.
Yes, attorney's fees, and basically it's got three potential liability prongs if you're the plaintiff, and it's either the other side was stubbornly litigious, or the other side caused you unnecessary trouble and expense, or there was bad faith, and this is all pre-litigation transaction situations. And or the third one is in the preceding circumstance, did the person act in bad faith? I've got a cite here from 2013. It says the Court of Appeals has recently clarified that the defendant's conduct authorizing a fee award under 13611 must arise from the transaction underlying the cause of action being litigated, not conduct during the course of litigation itself. That's Fletcher versus C.W. Matthews Construction Company, Inc. That's 2013 Westlaw 33-88872, Georgia Appeals 2013. I'm sure there's another site on that by now. So you got to look at what happened before the litigation ever started. But essentially, the first two prongs, stubborn litigiousness and unnecessary trouble and expense, are really an inquiry as to whether there's a bona fide controversy between the parties relating to the particular claim in which the plaintiff is successful. And the Rivergate versus Rivergate Corp of Atlanta Indoor Advertising Concepts case, 210 Georgia Appeals 501, 1993, sort of goes into that. So a bona fide controversy is essentially, in my mind, if there's disputed facts over what did happen, and it's credible people testifying on both sides, that's going to be a bona fide controversy. And if there is a bona fide controversy, then you don't have stubborn litigiousness, and you don't have the causing of unnecessary trouble and expense, because litigation is necessary to figure out what's the truth. And so on those two grounds, you're likely not to recover under 13611 if a bona fide controversy exists. So with respect to, I'm going to say unnecessary trouble and expense and stubborn litigiousness, I'm going to say you have to prevail a little bit more than just normally prevailing. Now, how about with respect to bad faith? Well, it's sort of an extra element. If you just win on a breach of contract claim, that's not necessarily bad faith, right? But if you can prove bad faith, then you're going to have which is generally an intent. You have to prove intent and certain seedy conduct, etc. So it's a harder, if you can get it, you can recover, but you have to prove it, which is hard because people are always going to deny. They're always going to have excuses as to why they did things. So I'm going to say that's a little bit closer to a prevail plus plus. All right. Now, with respect to the topic of today's, who knows whether you have to, and under 13611, whether you have to get a positive monetary recovery to win, to get attorney's fees if you're pursuing a 13611 attorney's fees claim.
As opposed to just an injunction?
Well, no, I'll say as opposed to a liable but no damages. Okay, the answer is you have to prevail and you have to get damages under Georgia law. A party must obtain an award of damages or other relief. This addresses Mr. Meeks's issue. You can get, if you get an injunctive relief, that's considered to be a positive result. In order to recover attorney's fees under 13611, that's Georgia Department of Community Health versus Data Inquiry 313, Georgia Appeals 683, 2012. So you definitely have to prevail. And how about with respect to if you have a counterclaim, what if you have 5 causes of action, you only prevail on 1? Can you get the attorney's fees associated with all of them? No, you can't. And what if you have a counterclaim against you and you're having to defend at the same time you're pursuing your claim? So you must allocate. How do you go about allocate or segregating your fees? How do you go about doing that?
Well, if you're really good, you keep track of it.
Okay. So it's no time like the present, right? If you're going to be, if you think you're going to have this issue down the road, you want to set up your billing immediately, where especially if you have a claim, let's say you have 1 claim and 1 claim on a counterclaim or 1,000,000 counterclaims against you. I actually set up often 2 billing files, one where I bill for the pursuit of the claim, one where I bill for the defense of the claim. Second layer to that, it's less good, would be, just put a little D in front of your defense claims and a little P in front of your plaintiff activities, so that at the end of the day, somebody can go through with fairly good testimony saying, on that day, I made a contemporaneous note, that's what I was working on, that's how much time I billed to that particular activity, and so this is how much I ought to get for working on the plaintiff side. Now, it gets a lot worse if you have a lot of different claims and they're all intermingled and you don't know which one you're going to recover on. But you could theoretically set up some sort of coding system to, if you really, really work on 1 claim out of 5 all day, for a good part of the day, you could put a notation regarding what it was or actually describe it in your time entry. One way or another, who's going to be determining whether or not you get these fees? A jury. And somehow or another, and if not, if the jury determines in your favor, who's going to be looking over whether you should have gotten those fees awarded to you? The Court of Appeals, or potentially a judge in a JNOV, right? So you better have something persuasive that can lead the court to believe that mere speculation is not being entertained as part of awarding these fees. Yes.
How do you handle tasks that are overlapping, such as preparing for and attending a deposition, where issues arise relating to, obviously, all of the claims? What do you do about that?
Well, you better be creative. You could obviously, sometimes there's a lot harder claims. You could make a notation, or at least a mental note, about how much of that was spent working on one area versus another. For instance, plaintiffs versus counterclaim. And then ultimately, whoever's testifying at the end of the day regarding why we should get this certain amount of a fees, you can point that out in your testimony. I think that 2/3 of this was spent me trying to get that person to admit that they had done my client wrong. The rest of it was explaining that the letter didn't make it. The 5 minutes of it was spent explaining that the mail didn't deliver a particular letter. Something like that. But one way or another, they're going to have something to go on to separate out and to deduct the time associated with the non-recoverable fees. And I would highly recommend, if you're presenting a claim, to do that affirmatively when you're presenting your claim, to sort of take away the cross-examination that somebody's going to do of you. If you go ahead and say, I know that I spent at least half of this time, working on the counterclaim, the defense of the counterclaim, then maybe you can just preempt the cross-examination. Yes?
Sometimes if you have a very complicated scenario where you have all these billing issues, you can propose to the judge that you deal with this in briefing and submissions to the court and not have the jury deal with it. I had a case in federal court years ago where we represented the plaintiff. It was a diversity action. We had a 13-611 claim. It was the late Judge Owen Forrester. Mm-hmm. And at the pretrial conference, we were laying out the issues of having to prove amounts of attorney's fees. There were lots of claims, etc. He just said, I'm not doing that. He said, I'm not letting the jury have to sit through all of that. He said, I'm going to do it. So if you went on liability on your 13-611 claim, you're going to submit briefing and affidavits, et cetera, about your attorney's fees, and I'm not going to subject the jury to that. We ended up winning on the 13-611 claim and then did it that way. The other side kind of reluctantly agreed.
Well, I was about to say, did anybody ever take that up and try to determine whether the right to recover attorney's fees under 13-611 was available at the time of the passage of the Georgia Constitution or whatever, to determine whether there was a right to a jury trial on that issue?
I mean, he pretty much strong-armed both sides and to say this is the way we're going to do it.
And so I was actually thinking about that a few minutes ago. There are a number of things you have to consider when you're presenting this. So do you have a bifurcated trial where if you're the defendant, would you like to have a bifurcated trial on the issue of 13-611? And when would you determine liability?
Only after the jury's come back with liability on the substantive counts.
And why would you do that? Well, if you're the defendant, why would you want to do that?
Well, because you don't want them having the idea that really by having to consider attorney's fees, they're already thinking you may have done something wrong.
Well,
As if the court's telling them that the defendant's done something wrong.
Okay. Now, if you're basically the defendant, you would think, if bona fide controversy will knock out 13-611, you would think the defendant would have the right to put up his defense before it's determined whether, for instance, a directed verdict should be granted on those grounds, right? Theoretically, a plaintiff could undermine their stubborn litigiousness and unnecessary trouble and expense bases for recovery by way of their testimony on direct on the case in chief. But one way or another, you think the defendant would have the right to defend, and then there'd be a directed verdict motion, and then the judge would either let the 13-611 go to the jury or not. Jury would give a checkbox on the jury verdict saying, I think there should be a recovery of attorney's fees, and then you'd have a subsequent trial, a day of hearing or whatever, on the issue of how much. But if you're the plaintiff, what would you like to do, possibly? If you think you got a really good case and that you're a really good lawyer and a really good witness. Well, first of all, when you're doing if you're in federal court, when you're doing your initial disclosures, if you're in state court, when you're doing your discovery interrogatory answers, you better list somebody who's going to testify regarding expert testimony on the reasonableness and necessity of the attorney's fees incurred as part of the disclosures or as part of the interrogatory responses, so that you won't be precluded down the road from presenting expert testimony on that subject matter. And if you're the lawyer for the client, can you provide that expert testimony?
Yes.
Yes, you can. I got a citation for that, but yes, a lawyer is competent to testify regarding the reasonableness and necessity of their own attorney's fees. And so, if you're the plaintiff's lawyer and you're putting up your case in chief and you think you got things rocking and rolling presenting your case, and the last thing you're going to do as part of your case in chief is present your attorney's fees plus whatever you're going to have to incur in defending the defendant's defense of the case, what would you like to do to get on the stand? You can get on there and describe all the rigors and problems that the defendant drug you through and all the scandalous activity they caused that made proving your case harder, and how they denied things that you ultimately proved were true, etc. And then tell them how reasonable your very high bills are, right? So in theory, you want to be able to be the one to be potentially be the closing witness of your case if you think you can do a pretty good job of that, and the other side's not going to be very good at cross-examining.
Congratulate them on hiring such a wonderful lawyer.
That's right, and you can
You really had to be on your game and put up a tremendous fight to combat someone of that caliber.
And you can also do things like, and I am so pleased at my ability to strike a jury. And the thoroughness and attention I gave to it, it cost us a half a day of work. I don't know if that would go over or not. I've never actually seen that tried, but one way or another, you got to be prepared to have somebody to do all this allocation. And you've got, the statute actually says reasonable. I went back and reread it, but the case law almost without fail says reasonable and necessary. And that both necessity and reasonableness need to be proven. Now, so let's think about possible attacks on a necessity assertion. Let's say the plaintiff had 6 lawyers at trial, and it was a fairly straightforward PI case, car wreck case. Necessary or not?
Not.
Not.
I actually had that come up this year where we challenged 3 lawyers being present at a case where one of the lawyers really just sat and observed and had not been that involved in the case in chief, and yet they were trying to recover attorney's fees for 3 lawyers. Fortunately, the court found no bad faith or unnecessary trouble and expense and denied all of their claims. So, but we did get to the point of arguing that. Can I interject a question? The case law used to be that a defendant could not recover under 13611. If you have a counterclaim, but you're a defendant, that you couldn't recover. Is that still the case, or has that been overturned?
What say you, Mr. Boyle?
I'm sorry.
I'll answer the question. All right, so yeah, we've actually won cases recently where we got the entire counter, if it's a compulsory counterclaim, and a defendant brings a 13611 claim on the counterclaim, you can move to strike the counterclaim in its entirety. It's only if, and it's somewhat of a screwy rule, if it's only a completely independent counterclaim, such as you sue the party for breach of contract, they sue you for running into their car, then that the defendant can recover under 13611 for a counterclaim.
So strategically, if you think your client is going to get sued over something,
you better sue.
You should rush
first.
to the courthouse.
Yes. And that's been the subject of controversial newspaper articles and such.
Does that apply even if you rush and file a declaratory judgment?
It would, yes. I think anything that's a counterclaim is not fair game. And the reason is 13611 says the plaintiff may recover. And a plaintiff is a plaintiff. There's only one plaintiff.
Counterclaim plaintiff.
Now, but for years and years, it was open season for counterclaimants and for plaintiffs. All right, so I'm gonna. All right, so one thing you could do that Randy already brought up is attack the reasonableness of the rate of the party, the lawyers that are charging the fees that they're asking, that another party is asking you to pay. So, what kind of bases would you go through to determine whether the fee that is being charged on an hourly basis, let's say, by the lawyer that gave rise to the damages for the attorney's fees is reasonable or not reasonable? What factors?
You look at what other lawyers in the locale deal with the same kind of litigation charge.
Okay, so there's a geographical relationship there, and how would you go about finding the fees, prevailing fees for lawyers of a particular experience level in a particular locale?
Sometimes you can look at the Fulton County Daily Report, sometimes publishes rates. Obviously you can get declarations and affidavits from lawyers in the area, either to prove reasonableness or prove that fees are unreasonable.
Right. You can go to the newspaper, you can go to other lawyers and go find out what they charge. You can look at the bankruptcy records and that's to me, that's not a very accurate picture, but it is a picture. My observation of bankruptcy court filings is that people charge unbelievably high rates often in bankruptcy. I guess anticipating that's going to be chopped down substantially.
Is that true, John Reason?
They're always reasonable.
And then you can learn from your, let's say that somebody is seeking the expenses associated with a motion to compel or something of that nature where they're submitting an attorney's fees claim. You can see what they filed. The other thing you can do is you can, like if you're trying to determine what the rates are in a particular locale, you can use your experiences with those attorneys, or if they have attorneys from two different locales, one from New York and one from Atlanta, and the one in Atlanta charges $400 an hour, the one in New York charges $800, then and the person in Atlanta is a very well credentialed lawyer, you can certainly say, you know, to the jury, there was absolutely no need for them to bring this guy down from New York wearing a zoot suit to present this case. As you can see, the guy here in Atlanta is perfectly fine. And then what about the lawyer that's opposing?
Yes.
Let's say if you got the opposing lawyer is charging, you got $750 or $1,000 an hour cranking on one side, and you have a lawyer who's very competent on the other side who's defending the attorney's fees claim. And he said, well, I'm at $250 an hour. What's wrong with me? You know, if the lawyer is very good, a jury could say, well, darn, I don't know why they're paying so much money for those people, but they're not reasonable charging that much money, you know. So ultimately the jury could slash the fees on that basis, or the person defending the claim could have an expert come in and give sort of a summary of all the reasons why this person's charging, this team or this person or whatever is charging too much. It's not reasonable for them to be charging that much.
You can also find out the rate that the lawyer charges other clients. In this day of alternative fee arrangements, discounts, what have you, you can talk about like the most favored nation rate and things like that to show, well, they're billing $750 an hour to this client, but when they're working for this big client of theirs, they're only, you know, $500.
Mm-hmm. So you can do that through discovery or through cross-examination. What other factors? We talked about too high a rate if you're trying to knock down reasonableness. If you're trying to enhance reasonableness, you can show accolades and experiences and number of trials and success, etc. We've talked about too many lawyers. How about too many paralegals? Are paralegal charges sort of looped into attorney's fees? I think they are, generally speaking. So you could do the same thing with paralegal rates that you could do with attorney rates, and you can also do the same thing if they got too large of a staff and people are just sitting around twiddling their thumbs. You could attack them on that basis. Yes?
I've had opposing counsel stipulate to the reasonableness of the rate more than once.
Mm-hmm.
So, you know, if your rate is comparable to what they're charging, sometimes you can shortchange that just by getting a stipulation that the hourly rate is reasonable.
Mm-hmm.
Now, of course, they'll still fight on whether you're entitled to recover, but.
All right. And that's a strategy issue because it's possible the jury might think that person's so good they ought to get more money. Mm-hmm. But on the flip side, if the jury thinks the amount lawyers' charges are insanely high and none of it's reasonable, that can be to your benefit. Because once the jury decides, it's going to be very hard for either the trial court or a court of appeals to say, you know, it's against the weight of the evidence, we need to grant a larger attorney's fees award. Yeah.
You can also present evidence about what work was delegated and was not. Are they billing a team of associates at $300 an hour to do paralegal tasks? Are they billing paralegals to do administrative tasks and that sort of thing? So
you can look at the overall plan and see whether there's all sorts of inefficiencies in the plan. Or, you know, you can have a circumstance where you know that lawyer, you know the guy next door to the lawyer that just spent 20 hours researching this subject matter, just argued the case at the Supreme Court the day before, you know, and you could attack him on that basis. Why didn't you just ask the guy next door? Well, it's because I wanted to spend all the time researching myself and charge the client for it. But that's not a very reasonable thing to do. And if you happen to have that information, it's very helpful to undermine the reasonableness of the charges. If somebody is affiliated with the lawyer who's charging everything, could have done it, you know, 3 times as fast. And that's one of the things we talk a lot about at Taylor English is, where do you allocate the work so the client gets the most efficient outcome as far as the bill? Okay. Don, were you able to look up 13111?
Yeah, I was.
A topic came up right before we started. This is a provision of the code that if you have a note or an instrument of indebtedness, a party can make a demand against the defaulting party, has to make a demand, has to make it 10 days in advance and tell the defaulting party, if you pay me now, within the next 10 days, you will not incur attorney's fees. If you don't, then I'm going to get certain percentages of the amount that's owed in my recovery. Is that a sort of a general fair description?
Right, right. And, you know, this often comes up in form notes that banks have. And a lot of Georgia banks will use the same form. It's common to have a 15% of the amount owing principal and interest as being the attorney's fees owed. And that's proper under Georgia law. The statute 13111 has been amended in the last couple of years so that generally what you see in the form is you either see that the bank is entitled to 15% principal and interest as attorney's fees or reasonable attorney's fees. They'll say that in the note. The statute has recently been amended now so that whereas in the past reasonable attorney's fees was interpreted as being a percentage of, let's see, make sure I got this right.
It's 15% of the first $500, and then
Okay.
10% of the amount above that was the historical
Henry,
calculation.
I'm so impressed you had that at your fingertips. But now the debtor, when it's this reasonable attorney's fees, if that amount is going to be more than $20,000, has the right to seek a hearing on the actual attorney's fees or the reasonable attorney's fees for pursuing and collecting the debt. So you know that can be significant because that 15% of 500 plus 10%. I mean, if it's say it's $1 million note, that's a lot of money. It can be. I'm trying not to generalize, but you know, in a lot of cases, that's probably going to be more than what the client would have paid on a straight hourly rate. So the debtor now has a chance to reduce that liability.
You know, and it also, of course, causes more work for the plaintiff's side,
Right.
which means there might be a reason why the parties would negotiate to try to get that issue resolved. Whenever you put more work on somebody, there's reason to try to get it resolved. Now, did we ever determine whether 13111 is exclusive remedy if you have a note or instrument of indebtedness?
I haven't looked that up. I think I've seen a case where people were allowed to go into 13611. Go ahead.
Henry, I know
John?
there's case law out there that says at least with respect to late fees, since we usually see these in promissory notes, the promissory note might call for 13111 attorney's fees and also might provide that every month you're late with your payment, you owe $50 to the bank in late fees.
Mm-hmm.
Those are mutually exclusive. And there's case law where a bank has lost out on getting 15% of its principal and interest as attorney's fees because it elected to charge and accept some little amount, $50 a month in late fees.
Wow, that's not mentioned at all in the statute, is it?
No.
It's purely something the Court of Appeals or the Supreme Court came up with?
Yeah, and actually, and it's recognized in federal courts in Georgia as well.
Now, so let's go through the litany. Do you have to prevail in order to get these attorney's fees? Yes, because if you lose altogether, that means you don't have anything to collect as a percentage of, right? Do you have to allocate? I think you know you don't have to allocate, so do a red X there. That's one of the, and you'd have to do anything more than prevail. You have to prove any extra bad conduct or any extra seediness or anything of that. No, and so you also don't have to plus prevail. The only thing you have to do is send the notice. Do you have to prove reasonableness?
No.
Unless, you don't unless you do.
Yeah, that's right.
Right?
If the note says reasonable.
So we have a maybe there. And how about necessity?
Yeah.
Well, in a sense, you have to, because you have to send the notice. The notice is that if they paid anyway, then you wouldn't have to do it, right? You wouldn't get anything. So that's a good question mark. I'll just put notice right here, because if you send the notice and you get paid, you don't get the attorney's fees. And if you didn't, and you don't have to bring a lawsuit.
Yeah. It's been a while since I've done collection work, but I used to do some, and you could put that notice in the complaint and say within 10 days of service, you can pay this obligation and avoid the attorney's fee. So it didn't have to be a notice prior to the complaint. The notice could be in the complaint as of 12 years ago.
I don't know if that's still true.
If
I've been
it's
wondering
still
about
true
that
or not.
myself.
Yeah, no, we still
Still in practice.
Okay.
Yeah, often, what will happen sometimes, we'll send out the letter, and, we send it to the last address, and then we attach the letter to the complaint, and they deny receiving the letter, so then we'll amend the complaint, and we'll put that language in there in a minute.
And I'm going to go ahead and fill these out a little bit. I would say you have to prevail plus on the frivolous litigation things. On 9/11/68, there's a question mark there. You definitely have to allocate. There was a case involving 9/11/68, which is Canton Plaza versus Regions Bank, 2013, Westlaw 5614340, October 15, 2013, where the plaintiff failed to segregate and they were unable to recover. But in that instance, it was remanded. And this one more topic to discuss very briefly is, and I can certainly understand with respect to 9/15/14, where it was a judge that made a determination, and that if you lose on appeal because you didn't properly present your damages or the judge didn't allow you to, that they could remand it to have a hearing on what their reasonable attorney's fees should have been associated with this particular bad activity that the party that's being sanctioned did. But how about with respect to 13/6/11, if you fail to allocate at trial and the Court of Appeals reverses, should there be a right to have it remanded for determination as to what the amount of the attorney's fee should have been?
Yes.
I personally think no. I think you failed to present your case in chief adequately, that you have presented speculative damages that aren't recoverable if you fail to allocate. And so unless the court somehow errs by instructing you to do one thing or another and you object and they say do that anyway, that would be the only reason I would think that you would be able to remand, because how are you going to do that anyway? You're going to have a different jury making the determination on the attorney's fees from the one that originally determined you were entitled to attorney's fees. So, complicated situation. But, so if there's any takeaways, which would be think in advance of your case whether you've got potential for recovery of attorney's fees. If you do, make sure you disclose witnesses who would ultimately be able to prove up these attorney's fees. If you do, and you've got counterclaims or multiple claims, segregate your time or make notations regarding how much time you're spending on each type of issue, particularly if you've got a counterclaim, because you can't recover attorney's fees for defending unless you have a contractual basis to recover. And so that's one reason why I stress it now, because all this is forethought. And then, of course, don't forget before you rest your case to present your attorney's fees claim. I've seen that happen where people get all excited about they put their final witness up and they say we rest, and they go, oh my gosh, I forgot to have anybody testify regarding attorney's fees. And that can be, obviously, that can be a huge problem if the court makes you stick to your resting of the case. And the other thing is, you know, think about when you're drafting your time entries, how much redaction you're going to have to do in order to protect attorney-client privilege so as to substantiate your claims. One other thing I'll mention is there's a big debate on who has to testify. Does everybody that incurs time on the case have to testify? Or can one person testify regarding it all, somebody who does not have personal knowledge of the actual doing of the work? Or does somebody who's actually in charge of the work have to testify no matter what? If somebody testifies as an expert, what do they have to have? And in what form must the underlying evidence be upon which they are testifying?
Sorry,
So-
I didn't get that.
So there's a lot of questions there that need to be thought about in advance to make sure you have the underlying evidence, which is such as billings, and in the properly authenticated form for a person to opine on whether these fees should be, this evidence is sufficient to go to a jury. Anything else before we close? Thank you. Come back next time for Quillian's Kernel.